one. I don't think we got to talk about this last time, Brad, but this is a big one because we work with a lot of business owners, and it has to deal with a buy-sell agreement.
Oh, okay, great. Yeah.
Yeah. And the question here is, they're saying, I've heard that you can build asset protection into a buy-sell agreement. How does that work? So kind of a broad question.
Okay, great. Okay, so this is another one of those we could spend all day on, buy-sells, because it's a very, very specialized area, very narrowly tailored documents. So let's just first define what a buy-sell is for those who are listening that they may not know. Okay, so I kind of just talked about it in the previous question. So ordinarily, when you have two people, Paul, let's say, for example, you and I are in business together, all right? You're a 50% owner, I'm a 50% owner. You and I get along just great. We're great business partners. You're married and I'm married. And, you know, and I get along well with you. I don't get along so well with your wife and vice versa, right? So this way, if something happens to me, actually, something happens to you, you pass away, your estate plan, either probate or your trust, is going to say what? All of my assets go to my wife, right? Just like what mine says, all my stuff goes to my wife. If that happens, who am I now in business with? I'm now 50% Brad, 50% Paul's wife, right? Because I had no opportunity to buy that interest back. So by way of inheritance, I'm now in business with your wife. And now all of a sudden, what was a good relationship between the two of us now puts me, the surviving owner, as a difficult scenario, right? So the primary function for buy-sell agreements is to keep the business closely held. Because Paul, truly, what is it that you want for the benefit of your wife? Truly, what you want is that you want your wife to get the benefit of your 50% interest financially, and I want continued control of the company, right? Without your wife. So a buy-sell agreement is typically nothing more than a right of first refusal, and it's typically funded by a life insurance policy. So if you and I agree that the business in question is worth $2 million, your 50% is worth $1 million, my 50% is worth $1 million. I take out an insurance policy on you, I guess it's this way, you $1 million, you take one out on me on $1 million. And the contract says when Paul dies, I receive $1 million. I must use that $1 million to buy your interest from your wife, and your wife must sell it to me for that dollar amount, right of first refusal. Therefore, everyone's happy. Your wife got the $1 million, that's what you wanted, and I got 100% ownership of the company. That's what I wanted. That's the very basics of what a buy-sell is. It's a right of first refusal, and typically on death is the most obvious example. Now, to your point, what else can we do? What else are triggers besides just death? Well, it could be incapacity. I don't want to deal with an incapacitated individual because now I'm operating with your wife via your power of attorney or through a conservatorship. So I want incapacity to be a trigger, permanent disability to be a trigger. Paul, what if you get divorced? Right? You're 50%, I'm 50%. We both live here in California, community property. What happens if you get a very nasty divorce, God forbid, and next thing you know, I'm in 50% with you 25 and a hostile spouse 25. You see the problem there too? I don't want that either, right? So divorce can be another trigger. Again, asset protection for the business owners. You lose your professional license, you're convicted of a crime. Now, filing for bankruptcy, insolvent. I don't want my half to wind up in the U.S. bankruptcy court trustees situation, right? What if you become insolvent? What if a creditor is trying to grab your stock? I don't want to be in business with your hostile creditor collecting off of me from a car accident or from a Nordstrom's credit card bill. All of these things are triggers which result in a right of first refusal. So not only most people commonly think of buy-sells as simply a death trigger. No. It's an asset protection trigger. It's a divorce trigger. It's an insolvency trigger. It's a bankruptcy trigger. It's a incapacity. It's a moral turpitude issues like the Weinsteins, for example, something like that. All kinds of stuff could be used for buy-sell. So we really take a look at existing buy-sell agreements and how can we expand it to also include asset protection for the business owners, not just who gets the company when they die.
No, great answer. And which kind of a question I thought of as you're talking about that is since we're talking about business partners, if one business partner is on the estate planning side, if their estate planning, something happens in their family, incapacitation with your business partner, or they pass away, and they don't have their estate planning done, and they're going to probate, and you're in business with them, is that a potential threat on the the business? What's the relation there?
Yeah, I'll give you a perfect example of this. This happened about a couple, 3 years ago. It's exactly what happened. One partner had an estate plan and the other partner didn't have an estate plan. And we just talked about probate, right? We just talked about probate. And so the 50% non-estate plan deceased partner passed away, and his 50% wound up in the probate estate. And now you got the court's involvement. Things move very, very slowly. And the person in charge was like an adult son who didn't know what's going on. And you got creditors' claims inside the probate arrangement. And there was fighting among the family as to who's going to take what, and inheritance, all kinds of issues happening at the probate level. In the meantime, I'm sitting here with my other half of the business. I can't do anything because my agreement says majority rules or supermajority rules. I can't do anything because the other half's tied up in this probate mess, this sausage factory, what's going on. And as a result of that, the client lost contracts. They lost vendors. They weren't able to bid for certain jobs, all while this was going on for almost 2.5 years in this probate arrangement. It was terrible for business. Had they had that buy-sell agreement, they would have immediately been able to grab that stock, and the money would have poured in the trust. Let the family fight over the money. That's fine. You got the stock. So it's a great point. Again, business partners, if you don't have an estate plan, at least have a buy-sell. That right of first refusal is critical. And preferably, you would have a buy-sell and an estate plan, right? They really work together. Buy-sell agreements and business partner estate plannings go together like ham and eggs, right? They're necessary components, right?
Yeah, and I guarantee you that very few business owners think about their other partners' estate planning. I mean, it's, kind of a personal issue. They don't think of it in terms of the business, but it's a big deal.
And listen, Paul, one of my primary concerns when I did my estate planning was to take care of my wife, right? I got proper life insurance. I made sure that there's enough income, the bills we paid, mortgage paid. My wife, of course, my children, but my wife is one of my primary concerns. Because I'm married. It's my life's partner. Okay. Well, if you and I are in business together, Paul, you and I are married, right? We're married business-wise. And what holds us together is our business, our arrangement. So just as important as a regular estate plan to the continuity of a marital relationship for family, the buy-sell is just as important to the marital relationship of the business, right? It's the same. You should give it equal respect because that's probably your largest asset. A lot of people are, as they say, real estate rich and cash poor, right? All the wealth in this country isn't necessarily held in cash. It's held in assets, business assets. And unless you have a source to turn that asset into cash for your family, then the asset isn't really worth the paper that that is represented by. So the buy-sell makes sure that those funds trickle down to the family on the deceased partner side, right? It's absolutely.
Yeah, it makes a lot of sense. And we just put out a blog on the unique aspects of estate planning for entrepreneurs. These are people who own businesses, and part of it is, they've got some unique things like a buy-sell to protect themselves. So good, very relevant point, which I know we actually you and I were talking about this offline because you were helping somebody recently that since you're mentioning marriage, another point here is on divorce. If someone's going, they go through a divorce, there's meaningful assets there. What are the issues involved in them redoing their planning coming out of that divorce? When do they start doing that? And what's important there?
Yeah. Okay. So that's another thing. So you do have a conflict between it. I say, when does estate planning and divorce collide? Right? They aren't necessarily work well together. And I know at least here in California that when someone files for divorce, you have at least a 6-month or what's called a temporary restraining order. You got things that you can't do. You can't move things around. And ultimately, when the divorce settlement agreement is executed, you have transfers of assets. The current estate plan gets revoked. The assets wind up going back to the partners based upon the settlement agreement on who walks away with what post-divorce agreement. So during that period of time where the divorce papers are filed, very technical rules as to what you can and cannot do. You can do estate planning. The problem is you can't fund it. You can't transfer the assets in because you have this TRO, this temporary restraining order imposed on the transfer of assets, which just makes sense. You don't want to file for divorce and have one spouse just transfer all the assets to Uncle Bob over here. You want to, again, they're trying to protect the divorce estate for the benefit of both spouses. So you can create a plan, because if you do pass away during the course of divorce proceedings, you may want the funds to flow to your now plan B. You can't do it. You can't transfer it during your lifetime, but you can do it through the probate process. This is where a will and probate is actually very friendly to us in a divorce setting, at least for that time period before you can transfer assets. I know it's a complicated answer. There's a lot to be said that I'm not saying, but I'm giving you the very broad brush strokes. But at the end of that transaction, the current marital plan typically is revoked, and both spouses walk away, and they both need new estate plans, new fiduciaries, new people to make medical decisions for them, et cetera. So as I said, there is a point where estate planning and divorce collide. Again, this is just working where you work with an experienced estate planner, because the last thing you want your estate planning attorney to do is start just willy-nilly putting plans together, start moving assets around as part of their just normal operating procedure. And next thing you know, you wind up in jail as contempt of court because you just violated a court's restraining order. So bad.
Yeah, not
Call
good.
that the law of unintended consequences.
And there's so much divorce today. It's a really sensitive topic that we're covering.